Good evening, ladies and gentlemen. My name is John Leonard. I'm chairman of the Board of Appeals, and we have a procedural and scheduling hearing, basically dealing with logistics this evening on the application of 16 Amor Road LLC. With us this evening are fellow board members Giselle Joffer and Brian Conley. And also present is Attorney Jesse Schomer on behalf of the applicant 16 Amor Road LLC. We did receive an application under General Laws Chapter 40B with respect to this application on or about June 1st. And we are here this evening to discuss scheduling and logistics for that particular application. I'm going to summarize some of these issues, and they're a little bit technical, but I think it would be too much of a burden to start reading sections of the Code of Massachusetts regulations. Under the Code of Massachusetts regulations, and the citation is 760 CMR 56.053 in parentheses, the Board of Appeals is legally eligible to stay the opening of an evidentiary hearing under 40B if the board has pending before it 3 or more 40B applications with collectively propose more than 300 dwelling units. And in this particular case, the parties are in agreement that the following 40B applications are still pending before this board. The first is 582 Blue Hill Avenue with 118 units being proposed. The second is 648 Canton Avenue with 124 units proposed. The third are the residences at East Milton with 101 units proposed. And the last is the Ice House application, which proposes 52 units. Those 4 applications total 395 units. The applicant in this particular application is in agreement, and we'll hear from Mr. Schomer on this, that the 180-day deadline for the board to close public hearings in this matter can be postponed and deferred until the board comes in conformity with the section which I just read of the general laws, subject to several conditions. And Mr. Schomer was kind enough to send us a letter. It's dated July 7th, 2021, setting forth the background here and setting forth the conditions which he proposes would be equitable for both parties to this application. And we thank Mr. Schomer for his letter and the detail of his letter. It has been published by the board on the board's website, so it's available for anyone who wants to read it in all of its detail. But Mr. Schomer outlines the section of the Code of Massachusetts regulations, indicates the applicant is in agreement to that the 180-day deadline on the application could be deferred. And he suggests 3 conditions. The first, which I'll summarize, is if, as of the date of the board's September 21 hearing on this matter, that's the proposed date, will give a specific date when we're continuing this matter. If the board is still eligible for a stay under the Code of Massachusetts regulations, then public hearings on this matter will again be deferred and continued without a substantive discussion of the merits of the application to the board's next monthly meeting for the following month, and the 180-day deadline to close the public hearing shall continue to be told. The second condition is that the same procedure will be conducted on a month-to-month basis until such time as the board's eligibility for a stay under the Code of Massachusetts regulations until it expires. And the third condition is that at the board's first regular monthly meeting, after the eligibility for a stay has expired, that the matter will be scheduled for a substantive hearing within the next 30 days. And the 180-day deadline for the board to close the public hearing on this application will begin to run as of the first substantive hearing on the application. Mr. Schomer, is that a fair summary of your letter to the board?
Yes, it is, Mr. Chair. In hindsight, I think I used the word condition, but I think I probably now would have preferred to use a word something along the lines of procedural consideration. And these were discussed with Judy Barrett, the town's consultant, and the town planner, Tim Zerwinski.
Okay, that's great. Let me go to my fellow board members and see if they have any comments on this letter, which is proposed really to be in the nature of a stipulation between the applicant and the Board of Appeals. Mr. Conley, do you have any comments regarding the proposed stipulation?
I mean, I think it's consistent with some of what we discussed last week. The the board seats different members at each monthly meeting, right? Or sometimes, as we know, more than once a meeting. So it's not that there's a monthly meeting that the same members will be sitting at, right? It's got to be, Mr. Laddard, Ms. Joffer, and me who were there. So we'll probably be needing to schedule special meetings to take this procedural step, right? I don't think it can be taken up by other board members who happen to have something scheduled. And maybe that's a question for you, Mr. Chairman. Do I have that right? We would need to schedule a special meeting of these three board members to take this procedural step.
Well, that's a good point, Brian, because I think Mr. Schomer in an earlier draft of the proposed stipulation, at least in a peripheral way, addressed that issue. So let me throw it back to Mr. Schomer. Mr. Schomer, do you have any difficulty if it was another board that continued this procedurally according to a stipulation if we adopted it?
No, Mr. Chair, I have no problem with that whatsoever. I believe it was an email correspondence that you were referring to, and there was a discussion between myself and town council and Judy Barrett regarding the Mullen rule, and specifically my understanding of the jurisprudence on the Mullen rule is that as long as there's no substantive discussion of an application, then there's no Mullen rule issue that's presented by the absence of one or more members at that hearing.
Okay, that's my understanding as well. Mr. Conley, do you have any comments regarding that explanation? Or
no, I mean, I just to say, make sure I'm understanding. So what we're saying with the Mullen rule, I think what we're agreeing here is that when we're convening on this, month-to-month basis to check the status on the various other 40B applications in town to see whether we've fallen below the number of units that are being pursued, the board will continue to extend month to month, but we don't need to have all three members, any one of these members, or I suppose any other member of the zoning board could take that procedural step. And it's not until we begin the substantive presentations in the project that we need to ensure all meetings have these three members. Does that sound right?
That sounds right to me. Mr. Schomer, do you want to comment on?
That sounds right to me as well, Mr. Chair. Obviously, I would leave that in your hands to confer with town council to make sure that she's in agreement with that interpretation, but that's certainly mine.
Right, and we'll be in informal conversation as time passes here, and some of these other pending applications are being resolved in order to coordinate and expedite this whole process. So, Mr. Conley, do you have any more questions?
I don't. Thank you.
Ms. Giselle Joffer, do you have any comments or questions?
Thank you, Mr. Chair. I do, with respect to who will be sort of tracking the progress of the different applications and making that information available at the monthly meeting?
Well, it will be either a combination of folks. It will be Bev Sutton, the clerk of the Board of Appeals, and likewise Judy Barrett, our consultant.
And Tim, I would also think Tim.
And
John?
Tim as well, yes, I'm sorry.
No, it's, yeah, I
No,
just,
my
yeah.
screen is limited here, so I don't have Tim on my screen, and I don't have.
no, he's not on. I just think he's a very good tracker.
Okay, I think that's right, and you could be sending out emails with some degree of reasonable in reasonable time before these meetings as to where all of this stands.
So that will happen. Yeah.
Yeah, okay, that sounds fine. Giselle, what else do you have to say?
Yeah, that sounds good. And otherwise, I'm in agreement that this seems to be in accordance with the relevant rules and also just, efficient and practical. I know that I'm sitting on one of the other 40B applications, which
Mhm.
Involves Mr. Schomer and the same developer. So it seems to make sense to finish one before starting the other. If that's the way it works out in terms of the numbers.
Great. Well, I'm in agreement with what everyone has said. Let me just ask, because as I say on my screen here, I don't have Judy Barrett. I don't have.
Neither do I.
Neither are here.
No.
Okay. Is there anybody else? They have not members of the public, but who Mr. Corcoran is there in the parking lot of Milton Town Hall. I understand Mr. Corcoran represents some neighbors to this particular project. Do you have any comments or questions, Mr. Corcoran?
No, thank you, Mr. Chair.
Okay. Bev, is there anybody else present?
No.
Okay. So why don't we put this to a vote and adopt it as a stipulation? So all those in favor of adopting Mr. Schomer's letter of July 7th, 2021 as a procedural stipulation in this case, please say aye.
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 Okay, so that's unanimously passed, and I think the next order of business is to discuss the date to which this application should be continued. And I have a reference in my notes here that what appeared to be the agreeable date is Thursday, September 9th. Is that agreeable to everyone?
Works for me.
Okay, Giselle?
Yes, fine for me too. Thank you, Mr.
Schomer?
Chair.
I'm sorry, Mr. Schomer?
Yes, Mr. Chair.
Okay,
That-
how
that
about,
works.
how about you in the parking lot, Mr. Corcoran? September 9th, is that a good date?
My only issue with September 9th is that I am flying to Boise, Idaho for my nephew's wedding on that date. I can join in by Zoom conference, and I'm not sure much will happen on the 9th other than to figure out where things are and how you move forward. So otherwise, September 9th is fine for me.
Okay, and I think that's in all probability the case. I'm not sure about the internet capabilities in Boise, Idaho, but it may be better than here in Milton, Massachusetts. We never know. All right, so why don't we put to a vote the date for the continuance for the board members. Are all board members in agreement that the next hearing date on this application pursuant to the stipulation of July 7th, 2011 should be Thursday, September 9th?
Yes.
Yes, Giselle?
Yes.
Okay, so we'll go over to September 9th. And Judy, excuse me, Bev, let me ask you a question, because it's so unlikely here that this particular application will go forward on the 9th. We can move one of the other applications that we have scheduled for Thursdays into the 9th slot. And I can handle that, the continuance as the preliminary matter at that particular hearing. Does that make sense to you?
It's certainly far enough ahead, so.
Okay, I think that makes sense. Let me ask you, Mr. Schomer, is there anything else that you want to bring before the board, or any comments you want to make?
Just one question, Mr. Chair, and put this to the board members and perhaps also to Ms. Barrett, who I see has joined us.
Mhm.
The idea of starting the process of appointing peer review for this project, which I presume the town intends to do. This could be, since we have at least at this point approximately 2 months until we'll be back together, this could be a good opportunity to get them started on that process. Just an idea.
Ms. Barrett, do you want to be heard on that?
I think that's perfectly fine if the board wants to do that. I mean, we had started to try to do that for the residences of East Milton.
Okay, and I guess the only question I have is that as long as the parties are in agreement, and it's consistent with the stipulation that the securing of peer review at the earliest date that we can get it done would not constitute the beginning of substantive hearings in this particular application. And I think we agree with that. Do we not, Mr. Schomer?
We do. Yes, we do.
So that makes a lot of sense to me, but we have better minds than mine here. Giselle, do you have any comments on doing the peer reviews while we're in this position of limbo?
I think it makes sense to start getting moving on that if, as you said, it doesn't impact what I would describe as a tolling, right? If of the 180-day limit. So if it's just viewed as, background work that we can get started on without impacting that. And I think as a practical matter, Ms. Barrett handles that. So if she has the bandwidth with everything else that's on her plate, that sounds fine to me.
That's fine.
Okay, and Mr. Connolly, what do you have to say?
I agree.
Okay, so we'll start the process of scheduling peer reviews on the particular application, and Judy will leave that in your trusty hands. Is there any other information that you need from us, or any votes you need from us?
I don't believe so, Mr. Chair. Thank you.
Okay, Ms. Barrett, anything you need from us?
I'm fine. I can start the procurement process. I'll get quotes from the peer reviewers, and do I have the board's permission to communicate the quotes to Attorney Schomer so we can get the escrow account funded, because those guys aren't going to start until we actually have the funding in place.
Yeah, we certainly do. That's certainly procedural, and that's one of the issues we always have in these applications, particularly at this time. The peer reviewers are so immersed in other projects and in their private business that it takes them 3 or 4 weeks sometimes just to get their first review done. So
Right.
that would be very, very helpful.
Sure. No problem.
Mr. Schomer, anything else you want to bring before the board?
Not tonight. Thank you very much, Mr. Chair.
Okay, let me just ask my colleagues whether they have any other issues they want to discuss. Giselle, do you have any other issues?
Nothing from me, Mr. Chair.
Okay, and Mr. Connolly?
Nothing for me.
Okay, so I think we've covered the bases on all of this, and so we're going to continue this application to September 9th at 7 o'clock. Or should we do that a little bit earlier, Bev? What do you recommend? Should we do 6:45? Or I don't think it makes a big deal. It's if we do 7 o'clock, continue the September hearing date, and then just go right into one of the other applications. It's certainly procedurally neater, but do you need to publish? If you want to publish a time, it's probably 6:45.
Are we scheduling more than one for that evening?
Well, we may, because what's going to
No,
happen,
no,
you're basically going to have an open slot.
So you'd have an agenda, Bev, with 2 items on it. Beginning at 6:45, it would be this, which I think will
Sure.
probably just be an administrative matter.
Yep.
And then moving right into 7 o'clock for the hearing, whatever that's going to be, if there's going to be one. It would just be an agenda with 2 items on it.
Okay, okay. Yep,
Then
I
that
was
makes,
thinking what we were doing tonight, 2 separate.
No problem. Nope, you can do
Okay.
1 agenda.
okay, so that's great. So
So
we're gonna
7:40,
continue
6:45.
to September 9th at 6:45.
Yep.
And I want to thank you, Mr. Schomer, for your hard work and diligence in your letters to us, particularly the July 7th letter. And we appreciate your cooperation, and we'll certainly try to extend the same privileges to you when we have the opportunity to hear this particular application.
Thank you very much. I hope everyone enjoys the rest of their summer.
Yeah, stay safe and stay dry for the next day or two, and see you on September 9th.
Very good. Thank you.
Thank you.
Good night, everyone.
Very
Good
good.
night.
Thank you. Good night. Thanks, Judy.
I think we sign out until the next, till like 10 minutes, John.
Then we have to sign in again.
I mean, kind of makes sense to me. I don't
Yeah.
know.
Okay.
Sure.
Why
Great.
not?
Okay. So
See you in a
everyone,
bit.
We can sneak away for 10 minutes.
Take care.
that makes-
Bye-bye.
Giselle.
Now,
Thank you.
enjoy. Be